All right, court will resume with the August 2nd, 2022 docket. And we're here with Ms. Olivares and Ms. Flores on F40, I believe it's F4741-21-4. In the interest of Susan Henshaw?
Yes, Your Honor, correct. Sarah Flores on behalf of Mr. Jim Henshaw, and we are the move-in in this case.
All right, good morning.
And Bella Olivares, Your Honor, for Ms. Laura Lee Liscano. And we also filed a response. It's regarding the drug testing that the parties were going to do, Your Honor.
Okay, so we have a motion to compel, right?
Yes, Your Honor. I filed a motion to compel on the 13th of July. We were previously here. I believe Roby was here at that hearing. On April 25th of 2022, the parties agreed that day to a order for drug testing. Each party was going to appear for a drug testing at Infinity Drug Testing Labs. At that time, both attorneys for the parties signed off on the order. It was agreed to, and it was later submitted for signature from this court. We did receive a receipt that Ms. Liscano did attend and go take the test. However, the problem is that after over 3 requests for the results, we never received results from her drug testing. So we emailed twice, sent a letter once, and made a phone call to Ms. Olivares' office. We did provide our client's drug test results. However, we never obtained any from her. Ms. Olivares did file a response yesterday indicating various different things, allegations of maybe like
I would argue
drug-
myself, my own, I
Yes.
object to it.
Your Honor, if I can finish. But however, none of this was ever explained to us. We were never told, hey, there's a problem with the testing, we were never given any explanation as to why we didn't receive these test results after several times. So therefore, we had to file a motion to compel so that we could receive the drug tests. I do have, I believe she's in the waiting room, the owner of Infinity Drug Testing. I know Ms. Olivares did have concerns that they're not trustworthy, they're not reliable, they're not professional. This company does drug testing for the city of FAR, for the city of McAllen, for customs. They have 3 locations valley-wide. They're a reputable drug testing lab. She is on so that I can ask her a couple of questions regarding Ms. Olivares's allegations in this case. Bottom line, we just want the results. That's it. We're not alleging she's a criminal or a drug user, but the parties did agree to this, and we're asking the court just to order that we receive the results.
In the meantime, did you give your results to Ms. Olivares?
Yes, we did, Judge.
Okay,
Your
and you
Honor.
said from
sorry.
them, you only received the receipt that they went, but
Yes,
no
like
results?
correct, like a test custody form. And I did call this morning the lab owner that way because we sent her a subpoena. She did indicate that there was an issue.
Objection, that would be hearsay. She
Well,
can
she's here.
testify when she
Is here
calls
to
her.
testify, that's correct.
Okay.
And so that's why we subpoenaed her, so she could explain what the issue was. But my point is, I had no,
Your Honor, I
reason
think
to
you already
believe-
heard everything. It's the same thing. If I may respond to it.
Okay,
so we
wait.
can-
if I could just finish. My point being that we've never received any explanation, any correspondence saying, hey, there's an issue of any kind. We just received no responses to our various requests for the drug testing. So
Okay.
we're also asking for attorney's fees for having to have filed this motion to compel to get something that the court ordered since April of 2022.
Okay, Ms. Olivares?
Yes, Your Honor, thank you. Your Honor, and how is that my client's fault? If anyone should have submitted those results, is the lab. If you recall, I don't know if you recall, but Roby was insistent that he wanted Infinity. I did not want Infinity. I wanted LabCorp. And you said, okay, let's do it there. So
Okay.
my client complied. I have my response with all the proof where she went. There was a young man, maybe that's their problem, that they don't have employees that are competent, because my client went on the time and the date 10 minutes before the test. They
Okay.
conducted the test. They took 4 hairs from her back of her nape, the edge, the middle, the center, and then the other edge. So they took her hair, they did the hair follicle. They said they didn't need anything from her, and they left. So I'm suspicious why they want this Infinity. And then they don't send us a test. We called the Infinity asking for where were the results. They said, no, your client needs to come back again. Like, hello, what is wrong with these people? Why didn't they test her there and ask her? Now, I don't see how that's my client's fault. The order says to go, leave the samples, and my client complied. I believe that Mr. Flores and the lab are very good friends, and I don't know what they're up to. Well, Miss Flores, you can shake all your head you want, but they could have called the lab also and asked where are the results. So she complied. I want attorney's fees because they hauled me over here when their people that they asked to do the testing didn't give us any results. So
if I can respond, Your Honor.
All right, Ms. Flores.
First of all, she agreed. Her signature is on the order, and she did agree to use that lab.
Okay.
Secondly, the order wasn't signed until later on, so I couldn't call the lab and ask directly for those results. It now is signed. However, since we didn't receive those orders, you'll hear testimony from the owner of Infinity that they called Ms. Liscano on May 2nd, indicating that they didn't pull sufficient amounts of hair, that they needed her to come back in, and she said she would go that day or the next day. But you don't have to believe me. You can get the testimony from Infinity. She knew that they were requesting her to go back. I did not know that until this morning when I subpoenaed her, because I didn't know that they had all these allegations. I didn't know if they just didn't provide the results, if they had them, if they didn't have them. Ms. Olivares could have called me, emailed me, written me a letter to say, this is the problem. I don't know what's happening. Maybe we could have resolved this. My point being, we've now filed this motion. I have Infinity here. We had to file the motion to get anywhere.
And what's her name?
Her name is Edna Sanchez.
Right there. Okay. Ms. Sanchez, can you hear me?
if she can do the video, Judge.
Okay, she needs to unmute.
Okay.
There
Okay.
she is.
Good morning.
All right. Good morning, Ms. Sanchez. Can you hear me?
Yes, sir. Good morning.
Okay, welcome here. We're here on cause number F4741-21-4 in the interest of Susan Henshaw. And you've been called as a witness. Good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. You may proceed, Ms. Flores.
Thank you. Ms. Sanchez, can you state your name for the record, please?
Edna Elizabeth Sanchez.
Ms. Sanchez, are you the owner of Infinity Drug Testing?
Yes, ma'am.
Can you give me the full name? I'm probably not saying it correctly.
Infinity Drug and Alcohol Screening.
Okay. And Ms. Sanchez, how long have you owned Infinity Drug Testing and Alcohol Screening?
Almost 12 years.
Okay. And how many locations do you have for your business?
3 locations, one in Harlingen, Farr, and McAllen.
Okay. We're here this morning because there was an issue with some drug test results for Ms. Laura Liscano. Is that correct? I mean, is that your understanding?
Yes, yes.
And I did call you and send you a subpoena this morning to be here because I was inquiring regarding issues with that result.
Question and answer, objection, Your Honor. That's not a question, it's a statement.
I'm asking, I did call you, is that correct?
Yes, you did call me.
Ms. Sanchez, is there any way, or are you the custodian of the records of all the records there with Infinity Drug Testing Labs?
Yes.
Therefore, do you keep business records in that lab of
Yes.
all the patients that come in?
Yes.
And is it your protocol to keep them in a certain order and you keep them for all your patients that come in?
That is correct. Yes.
And do you do individual drug testing?
Yes, we do.
And do you do both urine and hair follicle?
Urine and hair follicle. Yes.
Okay. Is that a new practice for you or have you always done that?
No, I have always done that.
Okay. And are your employees there in your labs trained to take specimens of for the hair or the urine samples?
Yes, that is correct.
And are there ever occasions where when you take a sample, an additional sample is needed?
Whenever an additional sample is needed, we will notify the donor. So for example, that will be only if the laboratory requests it. So if they request it, we'll call the donor and let them know, like, okay, you need to come back, and we'll give them the reason why at that moment.
Okay, and so do you send this hair follicle, once you collect the sample, you send it out to get the further test results?
Yes, the hair follicle is actually sent to a laboratory, and they are located in California. It's called Psychomedics. They're actually one of the best rated laboratories to do hair follicles.
Okay, and is that common for drug testing companies to send them out to be tested?
Yes, because here in the Valley, there is no hair follicle companies or laboratories. Also here in the Valley, there's not any DOT or what is called SAMHSA. It's basically a, how can I explain it? To be authorized by SAMHSA, which is somebody that approves these labs to do these type of tests. So here in the Valley, there's nobody that's approved by SAMHSA. So we do.
So they're all sent out?
Yes, they're all sent out.
Okay. And regarding Miss Laura Liscano, she did come in to take the test on April 29th of 2022. Is that correct?
Let me confirm. I have it here. Just to verify the date, because I don't want to be wrong. Yes, it is April 29th, 2022 at 1:53 p.m.
Okay. And then was that test ever processed?
Yes, it was sent to the laboratory, but it was returned.
Okay. And what happens normally when a lab test is returned to you?
Okay, so on once it's returned to us, if we need to recollect, we will call the donor. So for example, if it's in this case, it was a hair specimen, so they just come back, we do the recollection. If it's a urine sample, sometimes the laboratory may ask us to do an observed collection, which may mean that we're just going to observe the donor when they go into the restroom.
Yes, ma'am. So in this case, what was the, if she came in on April 29th and it was returned, was it given a reason why it was returned?
Yes, on May the 1st at 3:19 a.m., we received the result. And so we contacted the donor the next day on May the 2nd. It states here, Christy called her at 9 a.m. And basically the donor asked if she was going to get charged again. She was told no. And then she said that she would go in that day or tomorrow morning because she was working.
Okay. And that was, so she was indicating that she would go in later that day on May 2nd or the next day on May 3rd.
Yes.
And in your records, do you have that she ever did return?
She never returned.
Okay. So therefore, the lab test has not been processed in any way.
That is correct.
And does that happen? I don't want to say routinely, but is that something that does happen on occasion, that maybe the sample needs to be recollected?
Yes, it could happen. And sometimes because the way that we have to collect about 100 to 120 pieces of hair. So
Yes.
we don't sit there and count them. Basically in the training, the rule of thumb is basically the width of a pencil. Like if you have a pencil, about that amount. So that's usually what we do. Now, sometimes some people's hair may be thicker and we may think that it might be enough based on that rule that we use. And in this case, they just told us that it said unable to process sample due to insufficient quantity of submitted sample, please submit a new sample. And then it does state sample received with chain of custody intact. So everything else was right. It was just basically that there was an insufficient sample. There was not enough hair.
Okay. So you all completed your protocol in calling the client to come back, and that's where this situation ended. As far as the protocol, when the test is taken, do your clinicians or techs usually wear gloves when they perform this test or collect the sample?
Yes, it's really up to the technician, and only because touching the hair does not affect the sample in any way. And I say this because, for example, some people try to go dye their hair, they try to bleach it, they try to put all these chemicals, shampoos. So when a hair sample is submitted, what happens is that they melt it down to get all of everything that's inside the actual hair. So by us touching it, it doesn't affect it.
So
And
I'm sorry, go ahead.
so sometimes not using gloves is a lot easier because since we're cutting and we're trying to grab hair, this avoids us pulling their hair because it gets stuck on the rubber of the gloves. And so sometimes there is some technicians that don't feel comfortable using the gloves because of that. But it is not required.
Okay, thank you.
Very good.
And lastly, did Miss Liscano ever contact you after? Do you have that in your record that she was exposed to COVID or any viruses as a result of having gone in to take a test at your lab?
No,
Okay, so you have no record of that.
no.
Okay. And is there a certain licensing or anything that you have to own a drug testing lab?
There is no licensing needed. All we have to do is the trainings, and we have to make sure that the labs that we used are SAMHSA certified so that they could be valid.
Okay, and you have all of that in place.
Yes, yes.
Okay, I have nothing further for this witness. I'll pass this witness for now.
All right, thank you, ma'am. Ms. Olivares?
Yes, Your Honor. Ms. Sanchez, you
Yes, ma'am.
did not take the hair samples, did you?
I did not take the hair sample, correct.
Who took the hair sample?
It was my technician, Robert Rivera Jr.
And is he here? Is Robert Rivera there?
No, actually, he doesn't come in till 1 o'clock. He's a student. So
How old is Robert Rivera?
Robert is about, I want to say 19, 20.
19 years old?
Yes.
And what does he, what is his training that you gave him?
Well, we do online trainings. Basically, whenever someone is going to be doing either urine or hair follicles, we do trainings that have to be done online for them. And then we basically go in there and make sure that they're able to, for example, observe them and do mock collections to ensure that they can follow the protocols.
Okay, thank you. How long has Robert Rivera Jr. been working for you?
Robert has been with me, I want to say since last August. I'm not sure because a lot has happened during this time that he has been with me. And I say that because I lost my husband. And to be honest, I can't think of the exact dates, but I'm pretty sure that it was before that happened. Or maybe, no, maybe after. I don't remember, but I want to say about maybe 6 to 8 months.
Okay, 6 to 8 months.
Yes.
So not quite a year.
Not quite a year.
Okay, and I'm sorry about the loss of your husband.
Thank you.
Ms. Sanchez.
Thank you.
Now, do you, when you, well, before I ask you that, was anybody there besides Robert Rivera when these samples were taken from my client?
When the
To your
sample
to your knowledge?
I cannot tell you. I wasn't there. I don't think I was even there that day. So I cannot tell you if somebody was there with him.
All right. Did
Usually
you
it's,
have an opportunity to look at the agreed order on the motion for drug screening?
I did not look at it.
Ma'am?
I did not look at it.
Okay, so isn't it your practice that you're supposed to have this order signed by the court before you take samples?
Okay, so basically,
Is that your procedure? Do
No.
you need a court order?
no, we don't.
So how do you know that the court has ordered a hair sample, or what kind of screening you're gonna do?
Okay, so if the donor has a paper, we will ask to see it because yes, there's different panels. There's 4 different panels. One of them is
Okay.
for the 5 drugs only. And then there's the 5 drugs plus Adderall, the benzodiazepines.
Okay, Miss Sanchez, I'm sorry to interrupt you, but only the question so we can finish, okay? So how do you know if it's a urine or a drug test or hair follicle if you don't have the court order?
Okay, so we will ask the donor. If the donor doesn't know, we will ask them to for them to contact the attorney so that the attorney can let us know either by sending us an email or giving us that order, because sometimes they do not come in with that order.
Okay, so then if you made a mistake, it's because you didn't get the court order, right?
Right, we let them know.
Okay. All right, thank you. Now, where should he taken the hair from? You got experience. I believe you said you've had it for 12 years, your business, correct?
Yes, ma'am.
And when you do a hair follicle, tell the court how you're supposed to perform it.
Okay, so when the donor walks in, we'll verify their ID. Okay, and we have a pair of scissors specifically for hair, which is usually what hairstylists use. And we'll clean the scissors with the alcohol swab that comes inside the actual kit. So the kit is already prepared. It comes with the plastic bag where we send a sample. Inside that bag, there's an envelope. That envelope has a foil. The foil is where we place the hair, and it has an alcohol swab. It also has a red tamper-proof tape that we place over the actual envelope. And so once we collect the hair, so that we'll prepare, depending on the donor, if they have hair on their head, we can either take one whole chunk. Most of the time with women, we'll try to get from different places so they don't have one big bald spot, because it's harder for women to grow their hair. Men, usually they'll be okay with just take it from one spot and that's it. Our hair grows quick. If they don't have any head hair, then we'll take from their body hair. So it could be from their underarms, chest, or facial hair. Okay. So once we collect that and we see that it's about the amount of the size of a pencil, we'll put it in the foil in front of the donor. We'll close it up. The donor will initial on the envelope that they saw the collector put the sample in the foil, and then the donor, the collector, which was Robert, he would sign the envelope as well and date it, put it in the plastic bag that it comes in, seal it, and also, I'm sorry, before he seals it, he's going to put in the copy of the chain of custody, the first one, the laboratory copy. That goes in there.
So in your opinion, what went wrong?
Okay,
Why
so
didn't Robert collect enough hair? What went wrong?
okay, I cannot tell you, because from what I'm understanding, they checked it, and it was, usually he asked, like, do you think this is enough? Because it has happened to another coworker of his, and so sometimes he's paranoid, and he always asks,
Who's asking who? You think this is enough?
He asked Christy, which is another employee, do you think this is enough hair? And she said, yes, go ahead and send it like that. And we sent it like that. Because
are you telling this court that Robert asked Christy that day when she was there?
Yes.
When my client was there?
Yes.
But you weren't there, so who told you?
Christy told me.
Christy told you. So that's
Christy was
hearsay. And Christy's not here to tell the court.
No, Christy's not here. Christy is the
Okay.
one that called her on May the 2nd.
All right. Miss Sanchez, so my client complied, and actually it's a failure on your part that you all couldn't produce that report because you didn't, your employee, Robert Rivera, 19 years old, did not do it correctly. In essence, that's what happened.
But I don't think
Because if
age
you would have
matters.
done it, it would have come right because you have the experience.
Okay, but age doesn't matter.
Well,
Age-
I'm not asking you, ma'am, non-responsive.
You're telling me that
Hold on. You had an employee. The issue here is, did she go in to do the testing? Did she go in on that time, 4/29?
but she didn't
22?
come back when we asked her to
Did
come back.
she go in, ma'am? Please listen to the
Judge,
question.
objection. She's badgering the witness, and the bottom line is we don't have the
Okay.
results, and she's
That's
been.
not an
offered a chance to go
legal
back.
objection, Your Honor. Let me finish with Ms. Sanchez. Ms. Sanchez, isn't it correct that Ms. Lescano was there on 4/29/22? She calmly sat there. He took 4 sections of the hair, to your knowledge that somebody told you, but she appeared that day, did she not?
To answer your question, if she appeared, yes. If she
Thank
was
you.
probably there,
And
I don't know.
thank
I
you,
wasn't
Ms.
there.
Thank you. And she left the place once Mr. Robert Rivera released her. Is
Yes.
that correct?
Yes.
Okay, thank you. I'll pass the witness.
All right, I heard enough already. The bottom line is that she showed up like she was supposed to. This is Ms. Escano here. Then after being told it was an incomplete test, Ms. Sanchez, did your office call Ms. Escano personally
Yes, sir.
to
They
come
called
back
her-
again?
Yes, they called her on May the 2nd.
And she was supposed to be there, be there back on May 2nd or May 3rd, right?
Yes, that's what she stated, that she would be there that afternoon or the following morning because she was at work.
And she didn't show up.
She did not show up.
Okay, that's why we have incomplete results. We don't have results because she didn't show up.
Correct.
So that's the bottom line.
She showed up at the beginning, not the second
Oh, no,
time.
no. But we have testimony here that there are times when a test is incomplete, you're gonna call them again to come back again. Not just because they showed up, we still don't have results. She
Yes,
needed to
Your
go back
Honor,
again so
and-
we could get results.
Yes, and our argument is.
But how is it her
It's
fault,
been
you
used
know?
since May 2nd or May 3rd.
Well, let him go back also. Let him go back at the same
This
time,
test
and then
was
I'll go with
complete.
her.
All right,
Yes,
I've heard
yes,
enough.
yes,
Submit your
complete.
proposed orders, please, okay?
Yes, Your Honor, thank you.
All right, thank you all very
Thank
much.
you, Ms.
Bye-bye.
Sanchez, for your time.
Y'all may be excused. Thank you, Ms. Sanchez, for your
Thank you, Your
testimony.
Honor.
You may
Have
be
a good
excused.
day.
Thank you all. Have a great day. Bye-bye.
Number one.
Number one?
Mhm.
All right, number one, here it is. Friendly suit. Court will resume with the August 2nd, 2022 docket. And thank you all very much for your patience. It's been a long docket so far. We're here on CL 22-16-37D, Corina Salas as next friend of minor versus Stella Ramirez Valderas, Jesus Alberto Valderas Chavez. All right, the attorneys, we have
Good
Ms.
morning, Your Honor.
Heather.
Bill.
Good morning, Your Honor. Heather
I'm
Brew
sorry,
on behalf of the plaintiff.
Okay, good morning, Mr. Brew. I heard Mr. Garza. Good morning, sir.
I'm sorry, Your Honor.
Good
but-
morning. I'm here,
Go ahead.
Mr. Lobos.
Okay, and good morning, Mr. Villalobos, right?
Yes, sir. Good morning, Your Honor.
All right, good morning, folks.
Good morning, sir.
Who's going to be testifying?
I apologize, Your Honor. My client, the mother, was unable to continue to wait. This morning, she had to go back to work.
Okay,
So I apologize. It looks like we're going to have to ask for this matter
Put
to
it on
be
the phone, in the
recessed.
car before she goes in.
yes, is she, can we get her like on the phone or something? She can testify by speaker on the phone.
I can try.
Yeah, you can try, you can do that.
1 second.
Sorry about that. I mean, we have a long
It's okay.
docket so far.
Sounds like
And
you
we're
had,
not, and we're not halfway through, so
sounds
so
like
you're
you have a
like-
lot of interesting contested cases today.
yes, they're not as friendly like this one here.
Hence the term.
I did hear an earlier case that was friendly. It was a friendly suit. This is the second friendly suit. Yeah, but maybe we can get her on speaker. That'll do. And we're talking about Corina Salas, the mother. Yeah, I think Mr. Brew made a phone call, so let's see what. All right, let me see here. Make any contact, Mr. Brew?
Sorry, I got a hold of my assistant because the number I have was
Oh,
not
okay.
connected. She's gonna
Mm.
call her work and see if we can't get her to get on here.
Okay.
Okay, we have
Sorry.
one more we can do. Oh, we wait.
Okay, we're gonna wait a little while here. We're gonna try to do another one here. Which one?
Number two.
What? Number two? Is that another friendly suit?
Mhm.
All right. We're gonna jump to another friendly suit here. Let's see if I get the attorneys. That'll be Roger Garcia, Rudy, Raul.
Rudy Ruiz is here for
Okay,
and Jorge
Mr.
Salinas.
We got Mr. Jorge Salinas, Mr. Roger Garcia, and Mr. Rudy Ruiz. I think, can you all hear me?
Yes, Judge.
All right, folks, we're going to continue here with the August 2nd, 2022 docket. And we're here on CL 22-1923D, Angelica Maria Flores as next friend of minor versus Jaime Salinas. And I believe everybody is on. And Angelica Flores, I think she'll be the one testifying, correct?
That's correct, Your Honor.
All right. Miss Flores, can you hear me? You need to unmute, ma'am.
There.
All right, good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down, and once again, we're here. Court will take judicial notice of the entire file in CL 22-1923D. Angelica Maria Flores is next friend of minor versus Jaime Rios Salinas. All right, who's going to get it started here? Is it going to be Mr. Ruiz?
I can
All right,
proceed,
Mr.
Your
Ruiz, you
Honor.
may proceed.
Good morning, Ms. Flores. I'm Attorney Rodolfo Rudy Ruiz. Can you please state your name for the record, please?
Angelica Flores.
And Ms. Flores, are you the same person who brought this lawsuit on behalf of the minor child with the initials OR?
Yes, sir.
And is OR's birthday September 30 of 2010?
Yes.
And did you bring this lawsuit due to an auto collision that happened or occurred on November 27 of 2019?
Yes.
And is it your understanding that the liability insurance company in this case paid a total of $18,787.04 for the property damages?
Yes.
And is it also your understanding that this case or this claim has been settled for the amount of $15,000 with the underinsured insurance party?
Yes.
And is it also your understanding that these funds will be distributed on behalf of OR as follows? $5,000 will be paid to the attorney fees and $10,000 will be paid on behalf of OR.
Yes.
Do you also understand that the $10,000 for your daughter OR will be deposited into an interest-bearing account with the registry of Hidalgo County Court?
Yes.
Okay. Do you understand that this is the final process of this lawsuit, Ms. Flores, and that OR, your daughter, will not be able to reopen or bring another lawsuit when she turns 18?
Yes.
Okay. And do you also, or I'm sorry, is it your understanding that OR suffered injuries to her right knee?
Yes, on the back of her knee.
And as far as the injuries are concerned, Ms. Flores, has OR recuperated from those injuries?
So far, yes.
Now, you also understand that the settlement release, or did you understand the settlement release and the settlement documents that Mr. Rodriguez's office reviewed with you?
Yes.
And are you satisfied with my services and the services of Raul Rudy Rodriguez?
Yes.
Are you asking the court to approve the settlement, Ms. Flores?
Yes.
I have no further questions, Judge. I pass the witness.
All right, thank you, sir. Mr. Garcia?
Yes, sir. Thank you, Judge.
Yes, sir.
Ms. Flores, good morning. My name is Rogelio Garcia and I represent the defendant, Jaime Rios Salinas. Now, I understand that your daughter, Odalise, is 11 years old currently, correct? Is that correct?
Yes, sir.
And she's fully recovered from the injuries she sustained from the subject accident. Is that correct?
Correct.
All right. Do you understand that the amount that's being deposited into the court's registry, which is $10,000, will remain in the court's registry until your daughter turns 18 years of age, or there is a court order that that Judge Garza signs that will allow an early withdrawal? Do you understand that?
Yes.
Okay, good. Now, as far as settlement, do you understand that you have a right to a jury trial where a jury could award more or less or the same amount, but you prefer to waive that right and move forward and ask this honorable court to consider this proposed settlement? Is that correct?
Correct.
Now, earlier you were asked about a release, the documents titled Settlement Agreement and Release. I understand that you executed that document. Do you understand that by signing and executing the document, that will end the lawsuit against my client, as well as prevent you or your daughter from filing any additional claims or requesting any additional funds regarding this particular accident? Are you aware of that?
Yes, I'm aware.
Okay, good. Do you believe that this is a just and fair settlement and that it's in the best interest of your daughter that Judge Garza approved the settlement?
Yes, sir.
And are you now asking Judge Garza for it to be approved?
Yes.
Your Honor, that's all I have, and I will pass the witness. Thank you, Judge.
All right, thank you, sir. Mr. Salinas?
Yes, Your Honor, just a few more questions. I believe everyone asked most of the questions I was going to ask.
Okay.
Good morning. Can you hear me?
Yes.
You and your daughter, we've spoken before this hearing, is that correct?
Correct.
Okay, and in that meeting, you and I discussed the accident and how your daughter was injured, correct?
Yes, correct.
We also discussed her treatment and reviewed medical records and the bills, correct?
Correct.
And you feel that your daughter has fully recovered from her injuries?
Yes.
Yes. Do you have any anticipation that future treatment will be needed?
Not at the moment.
And I explained the distribution of funds of the settlement to you, correct?
Correct.
And you understand that from that settlement, 10,000 will be deposited into the registry of the court for Dalis in an interest-bearing account until she turns 18?
Yes, sir.
Okay, and you're asking the court to approve the settlement?
Yes.
I have no further questions, Your Honor.
All right. And what do you represent to the court, Mr. Salinas?
Your Honor, I believe that this settlement is in the best interest of the child, and I'm recommending that the court approve the settlement.
All right. Court will once again take judicial notice of the entire file. Court will hereby approve the minor settlement and will await a judgment for signature. Anything else from anybody?
I have nothing further. Your Honor.
Okay.
Judge, the judgment
No.
has been circulated. Everyone has signed off on it and will be e-filed with the court for your consideration by the
Okay.
latest tomorrow.
Okay, very well. And you'll agree on the fees as well?
Yes, Your Honor.
Yes, Your Honor.
Great, great. Court will await the judgment for signature. You all have a big excuse. Thank you very much. Have a great day.
Thank you, Judge.
Thank you.
Have a good day.
Bye-bye.
Take care.
Bye-bye.
Thank you. Have a good day.
You too. Okay, we're going back. All right, let's go back to CL 22-1637. The Corina Salas is next friend of minor versus Stella Valderas and Jesus Chavez. I believe everybody is on and we found Miss Salas. All right, sorry all again for the inconvenience. We've had a long docket this morning and I'm glad we found Miss Salas. Miss Salas, can you hear me?
Yes, I can.
All right, good morning, ma'am. Please raise your
Good
right hand.
morning.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. And who's going to get it started? Mr. Brew?
Yes,
This is Mr. Garza.
Oh, okay, Mr. Garza, go ahead, sir. Thank you.
all right.
Ms. Salas, how are you doing?
Good.
You can hear me okay?
Yes.
Okay, you understand that, let me back up. My name is Bill Garza, and I represent the defendants in this lawsuit. Do you understand that?
Yes.
And we're here today to prove up and ask the court to approve a settlement for the minor children, Camila Lara and Luis Lara. Is that correct?
Yes.
And this is regarding a motor vehicle accident that occurred in Texas on August 24th of 2021. Is that right?
Yes.
Okay. And I represent the defendants, and the driver in this particular case is Estela Ramirez Balderas. Do you understand that?
Yes, sir.
Okay. You understand that you have chosen to settle this case for the minor children, Camila and Luis, on the advice of your attorney, Heather Abreu, with the law office of Zeke Reyna. Is that correct?
Yes, sir.
All right. And you understand that typically in cases like this, if there is no settlement, you have a right to a jury trial. Do you understand that?
Yes, sir.
And if a case like this were to go to a jury trial, a jury could award more than the settlement or less than the settlement. Do you understand that?
Yes, sir.
Knowing that you're waiving your right to a jury trial on behalf of the minor children, is that correct?
Yes, sir.
All right. You understand that if the court approves this settlement for the children, Camila and Luis, that you are forever releasing and discharging the defendants and their insurance carrier from any and all liability and damages in this particular case. Do you understand that?
Yes, sir.
And that you will never, ever be able to file another lawsuit on behalf of the children relating to this case. And this is all the money they're ever going to get. You understand that?
Yes, sir.
All right. Now understand total settlement for both the children is $31,505.42. Is that correct?
Yes, sir.
All right. And just to clarify, break it up a little bit more, from this amount, Camila is going to be getting $21,682.91. Is that correct?
Yes, sir.
And then the amount for Luis is $9,822.51. Is that correct?
Yes.
Okay. And you understand first with regard to Camila that of the $21,682.01, the amount $15,427 is going to be made payable to you on behalf of Camila and the law office of Zeke Reyna. Do you understand that?
Yes.
And that amount, the 15,000 amount, is going to be used to pay back all the medical bills, medical expenses, attorney's fees, court costs, and lien amounts, if any, for Camila. Is that right?
Yes. Yes.
And the remaining net amount that Camila is going to get is $6,255.91. Is that your understanding?
Yes.
And then that amount is going to be deposited into the registry of the court in an interest-bearing account. Is that correct?
Yes.
Okay. Now, with respect to Luis, of that $9,822.51, the net amount going to Luis is $2,298.51. Do you understand that?
Yes.
And that amount is going to be again deposited into the registry of the court for the use and benefit of Luis in an interest-bearing account. Is that correct?
Yes.
And then the remaining amount, the $7,524, is going to be used to pay attorney's fees, expenses, and medical expenses for Luis. Is that correct?
Yes.
All right. And assuming the court approves these amounts for the minors, my clients and their insurance company will never, ever have to pay anything else again relating to this case for the children. You understand that?
Yes, sir.
Okay. And knowing all of this, you feel that this settlement is in the best interest of Camila and Luis, correct?
Yes, sir.
All right. Thank you. Have you understood all my questions today?
Yes, sir.
All right. Thank you, Dallas. That's all the questions I have, Your Honor. I'll pass the witness.
All right. Thank you, sir. You pretty much covered everything. Mr. Brew?
Yes. Sorry, I just want to make sure. I believe that we did cover pretty much everything.
Yes.
Can you let me know, Ms. Salinas, if your children have recovered well from the injuries that they sustained in the August 24th, 2021 accident?
Luis has never complained about any pain after our therapies and all of that. Camila is the one still. There's times I would have to pick her up from school because she can't be sitting down for quite some time. Nurses would call me that she was in pain. Camila, to this point, still has back pain due after the accident. So Camila hasn't really recovered fully. Luis has.
Okay, and you feel confident that the settlement that we've reached in this matter is a fair and reasonable settlement for their injuries that they sustained in the accident?
But I was told by the doctor, Camila would end up needing surgery in the future. She needs surgery now, but because of her age, she does not recommend it. She did tell me she would need it. She would end up needing it in the future. When they told me about how much she would end up getting, I really didn't think it was fair because the surgery to her back would not cost me $2,000. But they also explained to me that me fighting or wanting more would also have me paying by hour a lawyer, and that's something I don't count with. I don't have that kind of money. So that's when I decided, I would just leave it at how it was, how everything had ended up, the amount. So to your question of being fair, I really don't think a surgery for her would not cost me that. But I mean, there's not much I can do about it.
Okay, so are you here today to ask the judge and the court to approve the settlement for your children?
Yes.
Okay, and you understand that this is going to be final after today?
Yes.
Okay, and are you satisfied with the services that you were provided to you by myself and the law offices of Ezekiel Reyna?
Yes.
Okay. All right. I don't have any other questions.
All right. Thank you, ma'am. Mr. Garza, any more questions?
No, I think I'd point out.
I'll go ahead and address that.
Go ahead. Yeah, that's fine. I have no
Okay.
question on it.
Okay. Then, okay, Mr. Villalobos?
Ma'am, this is Jesse Villalobos. I'm the attorney at law for children. Ma'am, you do understand that in this particular case, there were many people involved in the accident. Is that correct?
Yes, I do.
Okay, and you do understand also that the $30,000 that are payable here, that's all that was left in the policy.
Mhm.
You do understand that, don't you?
Yes, I do. That's the reason why I didn't say I wanted to like fight it or keep on going to court. That they explained to me that was it. So I thought to myself, well, what am I going to fight for more? Like, where am I going to get more if that's
That's the point I'm getting to, because ultimately I have to make a recommendation to the court. And I want to make sure that the court understands that the reason that I'm making this recommendation is that is the policy is exhausted at this point. You do understand?
Yeah, of course I do.
Okay. So even though the local Camila still has some injuries, I mean, it's unfortunate, but that's all the insurance policy, the insurance proceeds that we have. You do understand that, right? Did you freeze? I think she froze. Hello?
Miss Salas, can you hear us, Miss Salas? I think she froze or something.
Yes. Well, Judge, at this point, that pretty much includes my questions anyway. I would, at this point, make a recommendation that the court accept this settlement. The paperwork has been it's been circulated. It's about to get signed off. Everything's been agreed upon, including the item fees, which will be on there.
Okay, and it was the policy limits. That's all you could get, right?
Yes, sir.
Okay. Anything else from anybody?
No, Your Honor.
All right, court will hereby approve the minors settlement in cause number CL 22-1637 in the case of Salas versus Valderas and Chavez. All right, thank you all very much. Court will await a judgment for signature. Y'all may be excused.
Mr. Villalobos has one more case with Mr. Ramos.
Oh yeah, Mr. Villalobos, you're not excused, Mr. Lobos.
He's got number 789. They have an announcement.
Okay, Mr. Villalobos, we have another case.
I'm going to log off my phone, Your Honor. And I think Mr.
Ramos, right here.
Yeah, okay. All right, thank you, Mr. Ramos. All right, Mr. Ramos.
They're there together. Jesse and Mr.
Okay, Mr. Ramos and Mr. Villalobos, we're here on F 2870-22-4 in the matter of the marriage of Edgar Perales and Brianna Perales.
Good morning, sir. Jesse Villalobos for Mr. Perales.
Good morning, Judge Juan Ramos, on behalf of the respondent, Brianna Perales.
Yes, sir. Good morning, gentlemen. Okay, what do we have here?
Your Honor, we have it's a contested hearing, but we've been talking about it. Mr. Ramos and I have been discussing some of the issues, and we're thinking that perhaps if we were to have a week, we might be able to resolve a lot of the issues. I don't know if the court is available in a week or so, allow us an opportunity to resolve some of these things.
Okay, I don't think the court will be available in a week, but if in a week you settle it and everybody signs on it, that'll do it.
Okay, when would the court be available, Judge? If it's not a week, when could the court be available?
September,
So we can
September.
It'll be early September.
Okay, other than September, Judge, anything this week that we might be able to, because we'll have to expedite it. We'll have to talk really quick if we have something. Actually, if we wait till September, it'll work. So if we have anything else, maybe this week.
I need to check because my court reporter is not going to be here.
Right, we don't have a court
It's because
reporter.
it's vacation time, Mr. Villalobos, for the court.
Yeah, and the court reporter's not going to be
And
here.
she's not going to be
She's not
available.
gonna be available. Yeah. Okay.
That's why it was set for today.
Yeah.
Yes, I understand, Steph. What do you want to do? The thing is that, I mean, we need some visitation. We need visitation. That's the thing about it. I mean, I would just as well. I want to work with Mr. Ramos also. I mean, I don't mind proceeding. Mr. Ramos requested some time. I'm sure he can also go forward, but we're trying to see if we can resolve something. But the problem is, we wait till September, then there won't be a fire under anyone, and my client.
In 30 days.
Okay,
So-
look, you're seeking right now today temporary orders?
Yes.
Well, that's what I'm saying. That
Yes, we are.
if in a couple of days you all agree on temporary orders, just sign on it. Everybody can sign on it, and the court will too, and that'll do it. We don't have to have a hearing.
The only problem is that if they don't agree to it, then I don't have any visitation for a while. So that's
Okay.
why then I'm in.
All right. So then, if you don't agree on it, can
I
we
guess
then have
if that's the
mediation?
case-
Can there be mediation now in case you all don't agree?
That would be cool. If we could, we could do a mediation by this week.
Yeah.
That'll light a fire under everybody.
Yeah, yeah,
If
yeah.
we cannot
Agreeing
agree to something,
right. Agree on a mediator, and if not, then give me a phone call or something, and I'll give you a name.
so we will agree to a mediator and we will mediate this case by Friday. By Friday, we'll mediate the case, sir.
To be mediated by Friday, okay?
Yes, sir.
Friday, 5 p.m. or later.
And we'll pick a mediator. That's perfect.
Okay, you were skipping there, Mr. Villalobos,
So
but I think you said that you're going to mediate by this Friday, and you're going to pick a mediator, right?
Yes.
Okay, that'll do it.
Yes, sir. Okay, thank you, sir, sir, and you enjoy your vacation, sir.
All right, thank you very much.
You feel
Have a
better,
great day.
sir.
Okay, bye-bye.
Number 3, Mr. Guerra, and I don't know if Mr.
Number three,
Kerr is
Mr.
here on
Kerr.
that case. or
Okay.
Mr. Pequeño.
How about court will continue with the August 2nd, 2022 docket, CL 22-2041D. That'll be Mario Rodriguez versus Gregory Kerr. All right, let's see here. We have Mr. Guerra. Mr. Juan Angel Guerra is right there.
Good morning, Judge.
Yes, sir. Good morning. And Mr. Pequeño?
Your Honor, this is Greg Kerr. I'm here on behalf of myself.
Oh,
Morning.
okay. Very well. Good morning, Mr. Kerr.
Good morning, Your Honor.
All right. And then we have who else? Mr. Frank Guerra? Oh, no. I think that's not the case. I don't want to mix the Guerras here. I think we got too many Guerras already. We said Juan Angel Guerra is in this case. That'll be Mario Rodriguez versus Greg Kerr. Okay, we have a hearing on motion to set aside foreclosure.
Yes, sir. Before I start, Judge, I've been talking to Mr. Kerr, and we were going to file a motion to dismiss against him and substituted for Mr. Pequeño, Juan M. Pequeño. Hold on. So Mr. Kerr did everything as a substitute. Mr. Kerr did everything that he's supposed to do. He complied with the legal ways of handling the trustee. So we have no complaints against him. The problem here, Your Honor, is that there was a temporary restraining order that was signed by this honorable court back in believe it was here. I have it here. Back in 6/2/22, which that would have been June 2nd, 22, to stop a foreclosure on some apartments.
Okay.
And I went ahead and sent it because on the notice of foreclosure, it lists about 5 different people that could sell the property. And so this is a problem that we have because we don't know which of those 5, are going to sell the property. Who do we put on the TRO? So we usually just put the first person and then we said, and any other representatives. And that's pretty much the way it works. Knowing that the attorney Pequeño is the attorney, he's listed there as also a trustee. I called him and I told him that we had done a TRO and he said, that's fine. We are going to go ahead and I guess honor it. And that was the end of that. We did have the first hearing, a 14-day hearing. We appeared. He gave us the impression that nothing was sold and that we were going to work toward paying off the apartments. My guy is ready to pay off that loan. And so everything was fine. It was not till later that we found out that no, that they did in fact sold the apartments, and that Pequeño himself, they bought it back themselves, and Pequeño was out there collecting rent. So attorney Pequeño, I called him back and I said, how could you gave us the impression. He says, well, the thing is that we didn't violate the TRO because the TRO says that Mr. Kerr could not sell the property. But because we list 5 other ones, I chose another person. And I said, look, the TRO only applies to Kerr and not you. So you go and sell it, and got Mrs. Lauren Christie to sell the property. And that's totally ridiculous. The statute requires 1 trustee to sell the property. And this is a problem that I'm having. So this is totally ridiculous about Mr. Pequeño. So what I'd like to do is substitute Mrs. Lauren Christie, who actually sold the property, and Mr. Pequeño, because he's also listed as a trustee, and it was meant under Mr. Pequeño's instruction, who's the attorney, to told Christie, go ahead and sell it because the order only says Mr. Kerr. And since we have 5 trustees, we're not violating the order. And I said, Mr. Pequeño, you are violating the spirit of the law. You know what the judge meant. It says, or any other representatives. I said, and we already had 1 hearing. And so I think the judge is going to be really upset. But as far as Mr. Kerr, I have no complaints against him. He has always been a very honorable individual with regard to being a trustee. He follows the rule to the law. So I have no problem with him. I plan to substitute and bring in Mr. Pequeño. Now I talked to Mr. Pequeño about this hearing, so I'm not sure why he's not here.
Okay, he's not in the waiting room.
May I respond, Your Honor?
Yes, sir.
I'm here for Mr. Pequeño. Mr. Pequeño is my law partner, and the lawsuit's against me. Mr. Pequeño's out of town, and so I'm here on behalf of myself. And I'm the only named defendant in this case anyway. And I do, may I address some of the assertions Mr. Guerra has made at this time?
Okay.
You know, what's ridiculous about this are these games that are being played to avoid a federal court removal and to foul up what would otherwise be a lawful foreclosure. What is a lawful foreclosure? Mm-hmm. I am the only named defendant here. I am one of 6 substitute trustees. The law is very clear. The property code spells out that substitute trustees are not proper parties to be held into court in their capacity as substitute trustees. There are proper parties that you can bring in to stop a foreclosure. The other people that are Lauren Christie, the person who conducted the foreclosure sale, is not my agent. She is not my employee. She conducted it outside. She was not sued in this case. Neither was Mr. Pequeño. Neither was the lender. The only person that was sued was me. And the reason that I was sued is because I'm a single substitute trustee, which runs afoul of what the law says you can do, and to avoid a removal to federal court. And this is not the first time we've seen this. We've seen this type of filing done over and over again in different courts. And it's not fair to me, because now I'm, just by virtue of a substitute trustee, I'm having to file responses, haul myself into court to defend myself. And I know Mr. Guerra said he has nothing against me. Well, he does. He has a live pleading against me. And in that pleading, he says that I've foreclosed on the property. He says that I didn't accept a tender of payment, which is not true. There's a lot of falsities in that. He says that I breached a contract. I don't have a contract with the plaintiff in this case. Furthermore, Judge, the plaintiff in this case is not even the owner of the property even before the foreclosure sale. The plaintiff in this case deeded the property to somebody else before the foreclosure. So the plaintiff doesn't even have standing. We've pointed all this out to Mr. Guerra. I asked Mr. Guerra repeatedly to dismiss this case against me, and he can go file wherever else he wants, but he's not done that. And I think what we've reached here is the point of frivolous filings and frivolous pleadings. I'm having to take away time from my clients, having to spend my own resources to come here and defend myself for a filing that Mr. Guerra should know at this point is frivolous. There's no law against multiple substitute trustees. I guess he could have sued every single one of us. It would have been wrongful. And if he would have sued every single trustee, I suppose if they were all served or were aware of the TRO, the foreclosure wouldn't have gone forward. But that's not what he did. And there's a gamesmanship there as to the reason he didn't do it. And it's because he's avoiding removal. The property code chapter 51 says you file against a substitute trustee. If they file a verified denial, then it's on the plaintiff to then come back and say, here's my cause of action against a substitute trustee. We filed that verified denial. There's been no response. This case, the statute says the court shall dismiss the case. But at this point, Judge, that doesn't stop this from happening. And like I said, we've seen this over and over again. It's unfair to the lender. It's unfair to the substitute trustee who's getting dragged into this just by virtue of being a substitute trustee. And so what I indicated to Mr. Guerra was, if you don't dismiss this case against me, I'm going to seek sanctions because I shouldn't have to be here for this. And he said, I understand. I'll get you dismissed, but the bottom line is he hasn't. And I'm still here. I'm still having to wait for a hearing, prepare myself, defend myself, and fight against claims that are completely and totally frivolous. And so I understand I guess I'll be dismissed, or this case will continue to be dismissed against me, but I will be following up with the court for sanctions, because I think this is, at this point, completely unconscionable. It's total gamesmanship, and it's not in accordance with what the law allows for suing or stopping a foreclosure. And so, I mean, a couple other things I need to point out. I know Mr. Guerra in his certificate of service said he served Mr. Pequeño with this motion. Mr. Pequeño was not served with this motion. We were lucky to have found it because we tracked this case for that reason. We've seen this several times on the pleadings now, where Mr. Pequeño's email address is misspelled. Now, Mr. Pequeño is on the eServe list. All it takes is clicking his name to serve him. That's not happening here. And the only reason we caught it is because my paralegal was tracking this and saw and found it. I just, this can't continue. I mean, I understand why Mr. Guerra files it this way, but it's wrong. And it can't continue to be allowed to permit it to happen, because it's wrongful to the lender and it's wrongful to people like me or other substitute trustees who have no bearing on any of the issues in a wrongful foreclosure case, Judge. We were named as substitute trustees. We conduct the sale. If I'm TRO'd, which I didn't do it. Somebody else did it that was not a party and that was not TRO'd. The final thing I want to point out, Judge, I know I'm talking a lot. At this point, we're looking at a title dispute. This, as you know, county courts don't have jurisdiction to entertain title disputes. We are, what Mr. Guerra, the relief he's asking, it's a motion to set aside the foreclosure. Well, now you're going to be deciding title if you do that. Mm-hmm. And so, I'm not going to, Mr. Guerra can decide how he wants to address that, but there's no standing and there's no subject matter jurisdiction anymore in this court.
Okay. All right. Thank you, sir. Mr. Guerra?
Your Honor, this arguments I've had it over and over. It's gone even to federal court, like he says, that I'm trying to go ahead and not take it to federal court. The problem with substitute trustees, they think that they can just be called substitute trustees and they can get paid and they're not responsible for anything. That is not the case. The case is very clear. Substitute trustee, okay, he's a trustee. He does not represent the bank. He does not represent the buyer or the seller. His job is to make sure that things done are according to the statute. Mm-hmm. He is saying that they have complied with everything, that by him being the substitute trustee, that he needs to check to make sure that the proper letters have been sent out. Everything that is outlined for a substitute trustee to do, he must go down the list and check that everything has been done. And if he checks the statute says appointment of a trustee, one trustee. The reason that you want one trustee, there's a reason for it. Because if the owner of those apartments wanted to go ahead and be present when they're going to sell his property, he has that right. So he needs to see who his trustee is going to be so he can stand right there next to him. So when they're conducting the sale, he can say, hey, wait a minute, there's another guy in the back who's trying to, raise his hand. He wants to bid a little bit higher. But if you put 5 or 6 or 7 or 8 or 21, my client is going to be going around like crazy. This statute and this argument has been done over and over. And I've even put, I think it was one of the trustees on another case, in case court number 5. And I asked her, we went ahead and subpoenaed her. And she said, Mr. Guerra is correct. The reason that we put a whole bunch of them is because we never know who's going to be there. And then he said, yeah, but the statute. And she said, yes, I've told that to our our bosses. But they say, look, 99% of the cases, nobody bothers. It's only Juan Guerra that does it. So if they want to go ahead and challenge me that I'm doing this because I just don't want to go to federal court, I'm doing it because the substitute trustee is the one that's doing it wrong. They're the ones that are not doing. Remember, Judge, this is the only area of the law where the person might lose the house or an apartment without judicial process, without a court, without nothing. That's why the property code says very specific, you must abide by the property code word for word, because you don't have This is the only time where there's no judge, no jury, and people are gonna lose their houses. So every little point of that has got to be made sure that it's done. Judge Crane finally went ahead and I have a 10-page opinion from Judge Crane in federal court and send it back to state court. And he says, this is correct. Juan Guerra is correct. This issue should be raised at the state level. They're violating state law, and it is a trustee that's violating the foreclosures, not the banks. The banks hired them as substitute trustees. They can't just say, well, I get paid $1,000 because that's what the other lady testified, but I don't have responsibility for nothing. You know, don't sue me. That's not the way it works, sir. I'm sorry, Mr. Kerr. Fortunately, you didn't do this. But if you look at the statute and the case law, you have a responsibility. You must be able to tell me that those 3 letters have been sent out. You must appoint yourself 21 days before, and it can only be 1 substitute trustee, 1. Now, the law changed. The law changed and said that there can be more than 1 trustees, more than 1 trustees, but only 1 substitute trustee, because when you buy a house, you say the trustee that's going to take care of if you don't pay. So the trustee and the statute, and that's where these people get confused. They say, oh no, now we can put a whole bunch of them. No, the statute says you can have more than 1 trustee, but only 1 substitute trustee. So that's the problem that I have.
Your Honor, that's just wrong.
Well, I'm
property
sorry,
code,
but that's correct.
Well, I'm gonna ask the court take notice of Property Code Chapter 51 or Section 51.0075, which contemplates multiple trustees. It's substitute trustees. It talks about the authority of trustees or substitute trustees. It says a mortgage servicer. This is 51.0075D. A mortgage servicer may authorize an attorney to appoint a substitute trustee or substitute trustees on behalf of a mortgagee under subsection C. So he's just wrong about that. What Chapter 51.007 also acknowledges or requires is that the substitute trustee is not the party to sue in one of these types of cases just because they're a substitute trustee. And that's what Mr. Guetta has done here. And when he says he does it, it's not I mean, when I've had these conversations with Mr. Guetta in the past, when I've asked him to dismiss this case against me, he's been point blank with me. He does it. It's a little trick he has to avoid federal court. And that to me already, you're frivolous at that point. You are suing me individually when you know it's wrong to avoid filing where you're supposed to file or to avoid ending up where you're supposed to end up. And so that's my big problem with this, Judge. I would have been fine if it just would have been dismissed and I'm not having to deal with this months after the fact. But now I'm here. I'm spending several hours defending myself on something that Mr. Guetta knows is wrong.
Okay, now the bottom line is we're here on movement's motion to set us out of foreclosure, right?
That's right, Your Honor.
So the foreclosure already happened, right?
That's correct, Your Honor.
It was done wrong or right, where it's
order,
gone.
Judge.
So now to set aside, that would be, again, you're talking about title, right?
That's correct, Your Honor.
They disobey your order, Your Honor.
Well, but let's see.
I did not.
But the foreclosure already happened. So now you're trying to undo a deed, right? Is what it is?
That's exactly what it is, Judge.
I don't know that the court can do anything about it because if we have a deed already, whether it's done right or wrong, that needs to be undone. That's the issue I have here.
But Judge, if that's the case, of what is the purpose of your TRO? If they disobey your order, you have no right to go ahead and, hey, you disobeyed my order. I mean, Judge, I order you not to sell this property and you sold it. So if let's suppose that it was Mr. Kerr that actually sold it, we would still have the same issue. So the question is, I mean, I understand that it's kind of a gray area. Are you contesting now title, which if that's correct, Mr. Kerr is correct that it would have to be a district judge, that we would have to send it up to a district judge and say, now we have a problem here because basically there is already a deed. And so if this deed is no good, and then obviously the only one that has that would be district court. So I'm kind of in the middle of making this for you we had the same situation with Judge Garcia, where the TRO was disobeyed. And so Judge Garcia set it aside. And so that's with the Court of Appeals with regard to kind of like the same issue as to whether Judge Garcia from County Court number 6 did, in his case, he was so upset that they disobeyed his order. And he just said, you know, I'm setting aside whatever you guys did is set aside. So that's being raised up to the Court of Appeals, which is basically the same situation in this case, Your Honor. So I'll do whatever this court, if you say now that whether they disobeyed my order, the bottom line is that you're now trying to set aside a legal paper that has been on file as a substitute trustee deed. And so in that case, it would have to be addressed by a district court. So I'll leave it up to the court.
Okay. All right, Mr. Kerr.
I would just say, you know, Mr. Guerra positive, what is the point of the TRO? I mean, the TRO was effective as to the person it was signed against, which is me. I stopped. I got the TRO, judge. I got served. I didn't do it.
Right.
The other substitute trustees aren't my agents. They can, if they're not restrained from doing something, they can do it. And so what's the point of the TRO? If Mr. Guerra says I violated the TRO, I guess he could come back to you and try to hold me in contempt for something I didn't do. And that's just my whole problem with this, is that why am I here? Why am I having to defend myself on this when I have nothing to do?
And that's my question, assuming that you did sell it. I'm just saying for the purpose of where jurisdiction rights, then let's suppose that it was that you did violate it and it got sold. Would this judge still have jurisdiction, or would you saying that now because it got sold, even though let's say for the purpose of speaking, which is what happened in Court 6, the actual person that was ordered to stop didn't stop it. I mean, sold
did sell it,
and so the judge got upset because obviously. But so my question is, if Mr. Kerr would be the one, where would you still say, Judge, well, now it becomes a district court issue?
Well, Mr. Kerr is correct. I mean, I cannot go against him because he's not the one that sold it.
No, I understand that. No, I understand. For this purpose, yes, I can substitute, in this case, substitute the person that basically sold it and saying.
What do you mean substitute? You want to amend the pleadings or what?
No, what I would do is I would amend it and I would dismiss against Mr. Kerr and substitute the defendants, the one that actually caused the problem.
I mean, I don't know if that's going to work or not. What I'm going to do is go ahead and allow you folks to submit proposed orders here for me to sign, and I'll consider something. But I don't know what can or cannot be done. Just it's up to you. Just submit proposed orders, please, and I'll look at it again.
Yes, Your Honor. I have nothing further. May I be excused?
Okay, you may be excused. Have a great day there.
Thank you, Your Honor.
All right, thank you. Bye-bye.
Just coming along real quick.
All right.
Criminal docket, Ms. Vanessa Flores. I don't know if for
Miss Flores, let me see here. Let me see if I can get Miss Flores on the. Or let's go to Mr.
the state also.
Sorry, Judge, I'm here.
All right, Miss Flores, you're here on CR 20-01387D. Ricardo Favata.
Yes, Your Honor. I represent Mr. Pavata. Yesterday, I received a call from his daughter. I don't know if there was some miscommunication, but he is set for today. Mr. Pavata doesn't have access to a phone that has Zoom. His daughter does. At this time, Your Honor, I would be just respectfully asking for more time. I don't believe he's logged on. I did try to get in contact with the daughter, but I do know that she works, and so I didn't get a response.
Okay. Do you know
them to discuss the case and try to resolve it, Your Honor, but at this time, I don't believe he's logged in.
Okay. And the daughter's name? Do you know the name?
I don't, Your Honor. She sent me a text message yesterday, and we were communicating via text message, but she didn't give me her name. She just explained.
Oh, okay. All right. I don't see. Court will note that Mr. Favata's name is not in the waiting room, so no, he's not around.
Yes, Judge.
So we'll do a reset.
If possible, Your Honor. Yes.
All right. Let me see if I can give me a date right now. And once again, CR I'm sorry?
Monday at 3 p.m.
Monday,
At 3 p.m.
3 p.m. That'll be what day on Monday? That'll be the 8th? 8 at 3 p.m. Monday, 8 August the 8th.
Yes, sir.
Okay.
Okay, thank you.
All right. Thank you, ma'am. Your excuse. Have a good day.
Restitution.
The CR 2206 118D Francisco Tovar Jr. restitution hearing.
Is that his client?
And that's Francisco Rayon. I don't know if it's him or not.
Good morning, Your Honor. Frank Guerra on behalf of Mr. Tovar. He is outside of the courtroom. He has checked in with the bailiff this morning. The hearing was at 10, so he did check in earlier today.
Oh, okay.
So who's this gentleman?
All right. I see Francisco Rayon. Which is his case? You need to unmute, Mr. Rayon.
Yeah, I got. This is a temporary spousal support reduction.
Okay. I don't think
Number 12 on the docket, Judge.
Okay,
Number
who's
12
your-
on the docket.
Oh, number 12. Okay.
That's Daniel Ramirez.
All right. We'll call you in a while. Okay, sir.
All right.
All right,
Thanks,
thank
sir.
you. Thank you. Number 12 right there. But anyway, state, Ms. Cantu, we're here on CR 2206 118D Francisco Tovar Jr. restitution hearing. Any announcement, Ms.
Yes,
Cantu?
Judge, we'd like to see if the victim Gladys Martinez is present.
No.
Gladys Martinez is not in the courtroom because otherwise I would have been made aware. And she is not even in the waiting room. No, ma'am.
Okay, Judge, the victim was notified of today's hearing. At this time, the state is requesting that restitution be set to 0.
All right, then substitution, restitution is going to be 0 for CR 2206 118D Francisco Tovar Jr. Did you get there, Mr. Guerra?
Yes, Your Honor. That's all the business I have. May I be dismissed, Judge?
Yes, sir. Thank you for your patience. It'll
Thank
be
you, Your Honor.
your restitution. Yes, sir. Thank you.
Back to number 12, Mr. Ramirez, and that's his client, Francisco Rayon.
Number 12, that'll be F46 24-21-4 in the matter of the marriage of Francisco Rayon and San Juanito Rayon.
The other side is Daniel Sanchez and the client Juanita Rayon, and they're not.
Okay, Mr. Dan Ramirez.
They have not called the court.
Can you hear me, Mr. Ramirez?
Yes, sir.
All right. I have.
Yeah, I can hear you, Judge.
Okay. And on the other side, it's supposed to be Dan Sanchez. And his
That's
client.
the opposing attorney, Judge.
Right. That they didn't show up. I don't see him in the waiting room. Mr. Sanchez or his client, San Juanita Rayon, is not in the waiting room. And what were we here for? For reduction of spousal support?
Yes, sir. Reduction of spousal support because, Your Honor, when we came to court in February of 2022, the court reviewed a list, an itemized list presented by Mr. Sanchez requesting temporary spousal support.
Let me call his office.
At that time, Mr. Rayon was working at another job.
All right, Mr. Ramirez, let me see if I can, we're going to call Mr. Sanchez. I know it's noon and whatnot, but let me see if we can catch him or something.
And then number 6, we'll come back to that.
We'll come back a little while, Mr. Ramirez. Number what?
Number 6.
Thank you.
Yes, sir. Number 6, that'll be Mr. Jorge Ortegon. There he is with his client.
Good afternoon, Judge.
Yes, sir. Good afternoon. He went from morning to afternoon, and then we have Miss Carranza, right? All right, she needs to unmute. All right, Miss Carranza, you need to unmute.
I apologize, Judge. Yes, I'm here on behalf of Ms. De La Cruz.
Okay, De La Cruz. There it is. Tatiana we got De La Cruz.
No, that's a witness.
All right, and all right, we're here on F1268-19-4 in the matter of the marriage of the De La Cruz, right? De La Cruz marriage?
That is correct, Your Honor. Jorge Ortegon, I represent Mr. Edward Estrada Jr. He is present to me to my right, Judge. We did file a motion to modify temporary orders. A little procedural history on this case, Judge. There was a divorce that was granted by this honorable court, and then essentially a motion for a new trial, which was granted by this honorable court. I had since been retained. We filed a motion to modify temporary orders, Judge. We are present. We are ready. We were set 2 weeks ago, Judge. We understand that Ms. Carranza did have COVID. We were able to enter into a Rule 11 concerning that so that she can get better, Judge. I actually ended up getting COVID as well, Your Honor, but we are present and ready for the motion to modify, Judge.
All right. Yes, ma'am. Ms. Carranza?
Your Honor, my client, Tatiana de la Cruz, is currently at the Women's Center at DHR. She is 33 weeks premature, and at this time, she is in the neonatal department of the high-risk maternity ward at the hospital. She is unable to participate in today's proceedings, and we do have a letter from the director of the neonatal department indicating that she is likely to stay hospitalized until the birth of her fetus. She is in a very delicate situation where the viability of the fetus at this point is questionable. And so for that reason, Your Honor, Ms. de la Cruz is unable to participate in today's hearing, and we are asking the court to reset us for a later date. Unfortunately, at this point, Judge, based on her medical condition, I don't know how much time we will need. And so that's my request this morning or this afternoon.
And Judge, if
Yeah.
I may briefly respond, Your Honor, I have been in contact with Ms. Carranza. She did, as a professional courtesy, did make me aware of the situation. We do understand the situation that is going on with Ms. Carranza's client, and we understand and respect whatever this court is inclined to do. However, Your Honor, there are some concerns which warranted our hearing and our request for a motion to modify temporary order, some extreme concerns that we do have regarding the health, safety, and welfare of these children. These children are currently in the custody of my client, Judge. This is a motion to modify temporary orders, Your Honor. Ms. Carranza is absolutely correct in her statement that we have no actual idea when the mother is going to be getting out of the hospital, Judge. For those reasons, Your Honor, we are asking for an interim order. If this honorable court is to reset this case for 2 or 3 months, Judge, 2 months, a month, whatever can be done, Judge, we can make sure that the kids are made available to this honorable court. However, upon discussing this case with my client, Judge, we are respectfully requesting an interim order allowing my client to have primary custody of the children for the time being, Judge, until we're able to be heard. This is a case that we believe time is of the essence, Your Honor. We have subpoenaed witnesses. And I do want to, and I will, of course, give Ms. Carranza an opportunity to respond, Your Honor. If I may, I'd like to proffer a little bit of information to support why we are asking for some interim orders pending this hearing, Judge. There was a social study done.
Okay, Mr. Ortega, one moment. We need to take a very brief break. I think one of us needs to go to the bathroom right now. Just wait a little while, okay, sir?
Absolutely, Judge.
Yes. Is Ms. Trevino going to be released, Sergeant Trevino?
Judge, I would just ask if this honorable court is not inclined to hold this hearing today, that all subpoenas that I have issued be ordered to remain in effect until further order of this court, Judge.
All right, so ordered.
Miss Sergeant Investigator Trevino with the Elsa PD is one of my witnesses, Judge.
All right, so ordered. We're going to reset this matter, Mr. Trevino, because we have an emergency here, but the subpoenas will still be good for the next hearing, okay, ma'am?
Okay,
All right, thank you so much for your patience and for your participation.
thank you, Judge.
Thank you, ma'am. Quick, short recess.
Yes, Your Honor.